We're first going to look at what happens if one spouse dies during divorce proceedings. And I'll take this opportunity to apologise in advance if I refer to decree absolute instead of final divorce order throughout this talk. In fact, it's inevitable while I'm still adjusting to the new terminology, so please do bear with me. So what if you have both a final divorce order and a financial remedy order? Well, if proceedings for financial orders have concluded and the final divorce order has been made, then the financial order is enforceable where one of the parties dies. If your client is the recipient, then they can rely on the order to make a claim against the deceased's estate for payment of whatever the order says they are to receive. So in terms of the impact on the different types of orders the court can make, it is worth noting the following. Lump sum and property adjustment orders survive the death of either party. In terms of periodical payments, both secured and unsecured PPs will cease on the death of the receiving party. Secured PPs will not be affected by the death of the paying party. Any arrears of unsecured PPs can still be enforced against an estate if the paying party dies.
Although some family teams or firms do not carry out work on Inheritance Act claims, it is something that family practitioners should be aware of, knowing when and what potential claims can be made and when it may be appropriate to advise a client to seek further assistance in this area. The Inheritance Act looks at whether the testamentary will or rules of intestacy failed to make reasonable provision for the claimant, and therefore may be an option available to the surviving and or divorcing or divorced spouse. For a surviving spouse, a claim may be made against the estate of the deceased under Section 1(1)(a) of the Act. However, for a divorcing spouse, we turn to Section 14 of the Act, which sets out, as can be seen on the slides, where within 12 months from the date on which a divorce order or nullity of marriage order has been made final, or a judicial separation has been made, a party to the marriage dies, and an application for financial provision has not been made,